Well, thank you very much indeed, and thank you to all of you for coming along this evening. Now, Michael, let me say, the way we're going to do this is that I'm going to interview Michael for half an hour, 40 minutes or so, but then we would really like to have questions from you. So please, as we're talking, if things occur to you, or if you've already thought of questions you want to put to Michael, then there'll be some time for that at the end.
And then I'm going to interview him. He doesn't know that.
Yes. So let's go back to the beginning, because it's sometimes said about, when I started at the bar, it was said about barristers that often, you know, they were the product of public schools, they then went to Oxbridge colleges, they then went to the manicured lawns of the Inns of Court, and they hardly ever noticed that the environment had changed. And that they were all wildly brilliant academically. Now, I want to go back to the beginnings for you. Did you fit
None of that applies to me. So.
Oh, I was going to say.
Yeah, I mean, I think I felt I was coming in from the outside, coming in from the cold in a sense. Yes, I did go to a public school, but that's the only element. The rest of it, I didn't go to Oxbridge, and I went to a new university, very new then, Keele. And I didn't do law, I did philosophy, and I was beginning to see in the potteries a very different world that I'd never witnessed before. So by the time I got round to considering I might become a barrister, only because, you know, celluloid of films, and it was a kind of romantic vision. I thought, yeah, I could do that. Maybe I could do that. I didn't know, but therefore entering the portals of the Inns of Court, which are so totally, in my view, out of touch, or they were then, and had remarkable rituals of eating. You had to eat dinners in order to qualify, and you had to eat them in a certain way, and you had to pass the wine. And, you know, these rituals actually permeated the four inns. So I think, yes, the people who tended to survive were those who'd actually experienced that at their schools, long benches and all the rest of it, and at Oxbridge. The collegiate system had worked their way all the way through, so they were part of a bubble. I think that has changed. Not enough, but it has changed, and it has made it very difficult for non-white groups, for women, and whole sectors of our community to really become represented within the profession, because the judiciary is taken from the profession, or was, exclusively from the bar. So it meant you had a bench that didn't represent where we live either. That's begun to change, but again, not enough.
And there were some fantastically exclusionary customs. I mean, I remember my first day in Chambers, and I was introduced to a barrister who was about to become a judge, and I offered him my hand, and it was as if I had put something extremely unpleasant in front of him. He sort of backed away as if I'd broken some terrible unwritten rule. And the rule was, back then, that barristers were not supposed to shake hands with each other. That was the custom.
And I couldn't call you Clive.
No, you would.
I'd have to call you by your surname.
Yeah.
I mean, you know, I have to remind myself of how cloistered and claustrophobic, you know, it was. And the other story, well, I sometimes tell it when I remember it, is one of my earliest appearances. You were expected to wear a black jacket, pinstripes, and a black waistcoat. I must pronounce it correctly also. Is that I didn't do that, and I was wearing a blue suit, so that was a bit
daring.
Yeah, absolutely very. And the blue suit had silver buttons. And so there was a phrase that was then used by a judge called Alan King Hamilton. I think he's passed away some time ago. But they had a phrase then. This is how bad it was. And I stood up to speak, and he said, "Mr. Mansfield, I can't see you." Which meant, I'm not going to listen to what you have to say because you're dressed improperly. And he had me around the back, meaning, you know, his chambers, and he said, "You can't wear that in public," you know. And I said, "Well, I just did, you know." Yeah. And so the next what I did is I cut off all the buttons. And but I mean, you know, it's a ridiculous situation.
It was kind of crazy. And by the way, the reason for barristers not shaking hands with each other I was always told, you'll correct me if I'm wrong, is that...
Sword.
Exactly, because we were all members of honourable societies, so the Honourable Society of Lincoln's Inn, Gray's Inn or whatever, it was thought rude and improper if you were members of that society that you shook hands, because the handshake, the derivation of the handshake, was to show that you weren't carrying a dagger or a sword, and so it was all considered very rude. Now, you set up a set of chambers, Tooks Court, which was very different from the norm. It was known as a left-wing set of chambers. Just talk us through why you felt the need to do that and how it all came about.
Well, it was propelled by the fact that the background I've just described rather quickly was such that I felt that it was not providing that diversity, wasn't providing opportunities for people like myself, and that it was a real struggle, and that we had to. And also, it was dominated by the grip that the Inns of Court had, where all the chambers were, in London anyway, were in the Inns of Court, the 4 Inns of Court. And so I thought, well, it's time to break the mould here. Now, one set of chambers, they were called Wellington Street, they had set up, and in one part of Covent Garden, in fact, and I knew all the people in it, and I said to myself and to them, I think, you know, we can start a movement here of getting people outside the Inns of Court and moving into ordinary buildings. And the vision I had, which was developed at one point in Lambeth, was to have chambers that were like neighbourhood law centres, where people can walk in off the street and see you and not have to go to some, you know, rather elitist building and establishment just off the Strand, opposite the Royal Courts. So that was the idea, was to build something quite different which provided an equal opportunity and really implemented that. So, you know, when we started off, there's only 6 of us, you know, at that stage, half women, and half of them were black. And then it grew in that, that mould and model grew, and we grew very fast because there was a community wanting to be served by us.
And what did you do? What did you strip out of the normal running of a set of chambers to make it different, to make it more equal? Because you know, traditionally the clerks got 10% of everything the barristers earned, and the senior barristers obviously.
We decided that I can't say it survived totally, but we kicked off by saying, right, we'll pool everything,
which was revolutionary.
We'll pool it all, and we'll divide it up equally. Obviously, those with a little more experience may have a little more, or they may have bigger cases and so on that need more expenses and costs. But we tried to make it equal from that point of view, and the clerks will be involved in that whole process. Now, that's very difficult to maintain, because once you get, and you're successful, those who earn more tend to say, well, wait a minute. Why, and certainly those who earn less are saying, why should we be paying the same rent? So you have to start differentials. So in the end, there were differentials. But the idea of a communal approach, but much more important even than all of that, was to ensure that, although I was head of the set, it was democratically run. Now, everybody said, oh, you're allowing the tail to wag the dog. And I'm going, I'm sorry, you know, I don't know which end of the dog you're facing, but as far as I'm concerned, I just feel that if you have a collective, so that's what we were, a collective deciding on policy for the set, from the colour of the wallpaper all the way through to the nature of the work that we took. And we were careful about what we did and who we represented. And although there's a taxonomic rule, of course, for the established commercial sets, they can decide on the basis of money who they're going to represent. So we were saying, well, wait a minute, it's important that money doesn't really come into this. We're ensuring that people who would otherwise not be represented sufficiently or well, we're going to concentrate on that area. So it led us into dealing with cases which had a social, human rights, and this is before the Human Rights Act, human rights aspect to them, social justice, if you like, people who appreciated the voice. It's not that, and in a way, it reminded me of an American series, which is why I'm doing the job, did the job in the first, called The Defenders, where they did do that, where they represented people who otherwise didn't have a voice, but they did not always win. A lot of the time they lost, but They may have lost the case, but not the battle, but not the war, because the individual clients would say, at last. You know, it's like a form of oppression. It drops off the shoulders, and they feel, thank goodness, you care, and you understand, and we've had our case put, you know, as strongly as it can be. That's what mattered.
Sure. Let me just ask you about the way in which the cab rank rule operates. Now, the cab rank rule is one of the ethical foundations of the bar, and it means that, you know, in theory at least, any barrister who is offered a brief is obliged to accept that brief, irrespective of what his personal or her personal opinions are of the client. Now, you were a radical set of chambers, and inevitably would have attracted a certain type of clientele. But what would have happened if, I don't know, it was the heyday of the National Front, the leader of the National Front had asked to be represented by a member of Tooke's Court?
Well, this is the perennial chestnut we were facing from time to time, because we were aware that obviously there were, and the professional rule had originally a very good purpose, which was to ensure that people got represented. Yeah. But when I did, for example, the Anchor Brigade case, one of the first cases I did, there was some difficulty in getting members of the bar to do that, and even more so when we got to the London bombings by PIRA defendants. And there was a real dearth. Suddenly, people evaporated and were busy, couldn't do the case. So I recognize the fact that, you know, there is a taxi rank rule, but it doesn't apply to those who are establishment figures who will disappear when the pressure's on. So when it comes to then having decided we're going to concentrate on ensuring people who would otherwise not get a voice, that one of those voices, for example, is a member of the National Front. Now, interestingly, because you make it public what you're doing, and I've never made a secret about the kind of work that I do and the political beliefs that I've got, they don't come to you. Because they realize, and I realize, that there's a problem were they to do that. Because I can only deal with it hypothetically, that if somebody did come to me and said, National Front or the English League or whatever they are now, and said, yes, okay, I would say, well, sit down. I want to explain to you, before you decide that this is what you want, who I am and what I stand for, and the fact that, you know, I will represent somebody I don't like, even their views I don't like. If at the end of the day, you're not going to turn around at the end of the case and say, if we lose it, and say, oh, well, I lost it because you didn't really put your heart into it, and even though you seem to. So I said, you've got to trust me as much as I might have to trust you for the purposes of the case. Are you prepared to do it? Now, I don't know what the answer would have been because it never happened. So that dilemma never actually crossed my path at all. Okay. Because once you make known what your identity, which is the current word, of course, what your identity is, then the people recognize that, you know, you're good for doing that, but you may not be good for them. That's fair enough, I don't mind, but that's how it works.
Okay. Let's talk about the cases you just alluded to the Guildford 4 and the Birmingham 6. Now, these were cases that exposed massive malpractice amongst the British police force and also the justice system as a whole, and led to a Royal Commission. We're going to have another Royal Commission. Just explain the way in which you became involved in those cases, and I'm just interested to know whether from the very outset you were aware of the scale of the problem. Just a little bit of background. So the Guildford 4 and the Birmingham 6 were both groups were convicted of pub bombings in the early 70s, early to mid 70s. And they were all convicted, and it later came to light that the confessions that they had made, through forensic evidence, through forensic examination, that those confessions were not theirs, effectively, or they'd been extracted from them. So it was a huge deal in terms of discrediting the British police who had dealt with those cases. Did you know at the outset the scale of the malpractice?
Well, perhaps not the scale, but we were aware, those of us practicing in, I'm going to call it the social justice arena, we were aware that certain people were targets, the usual suspects, and, you know, if they haven't done this, they've done something else, attitude, the noblesse oblige approach to it all. So, yes, I was aware of it, but the scale of it, no. And although you've mentioned the police, actually, and you've mentioned it's the system, what really staggered me when we got down to it, Birmingham 6, Judith Ward, Tottenham 3, a number of other cases, was not just the scale of the dishonesty and also the violence related to police investigations, then unregulated, now regulated, was in fact that it percolated, it had tentacles that went out into the whole of the system. So, for example, I suppose one of the high points was the Judith Ward case. That does repay looking at, because it was scientists were involved. In fact, in selective testing and non-disclosure of results and so on. I mean, the catalogue is quite vast. And it wasn't just, as it were, forensic scientists. It spread into other areas as well. So you had a whole system. So take the Birmingham 6, and you can see why. I mean, you get a massive bomb in the centre of London, blew up my car, photograph in the books, 2 for the price of 1 today, just out here. So I was aware particularly that there was strong feeling about actually the Irish and their presence, just as a strong feeling about other groups at the moment. And so one realized that this strong feeling, unless you've got superhuman beings in the prosecutorial process who stand back and stand above it, they're going to be influenced. And if they think they may have got the right person, then they bend the rules. They take shortcuts. And, of course, that was all uncovered gradually through that whole period. I mean, the classic was, I suppose one of the examples is on the handwriting front. It doesn't happen so much now because they've stopped doing it, but, where a statement was written on paper, and what they overlooked was, the indentations that come out on the sheet below. And it was something as simple as that a handwriting expert discovered years later, that the sheets that had been maintained as exhibits showed that the original statement said something quite different. It's as simple as that. And although, you think, well, they might have discovered that before, they didn't, because, it needs barristers, lawyers, aware of the potential of forensic science, which is another of the hot topics which I like to talk about, which is slowly developed such that, now barristers, I think, are more on the ball than they were before, judges as well, because it's the system.
So in order to take on those cases, to take on, if you like, to take on the police, to take on also a system that was perhaps inclined, its first base, its starting point was to believe what the police was, the evidence that the police were giving. Did that take personal courage? Did you feel that, it was you against the system when you were doing that?
Yes, I mean, I felt it because not only did I feel, entering the profession from my background, well, in fact, I'd intended to be, I know it's a bit glib, but actually, I have a railway family, and my father, he died before I got anywhere near the Inns of Court or anything else. He was honestly believing, and I honestly believed, that I was actually going to be, an engine driver of the Mallard exiting King's Cross up to Edinburgh. That's what I thought I was going to be doing, working on the railways. And suddenly I'm not working on the railways. I'm captured by films and so on, as I've mentioned, and then I find myself in an environment I know nothing about. I have no connections at all. Mostly those, well, not anymore, but mostly then, people who entered the profession, their fathers, their grandfathers, their cousins, or whatever, they're all related. They all know each other. And they're the son of whoever, some High Court judge or whatever. And I found myself right on the outside of it. So when it came to asking questions in court, I mean, just give another example, a scientific example, which was in the days when there was a lot of red evidence, particularly scientific. And I said, in one particular case, it was in South London in Croydon, and I just remember the place, and I just said to the prosecution, and in the end to the judge, because he made me say it. He said, what are you asking for? I said, well, I see the report, but I'd actually like to ask questions of the scientist who made the report. You what? Mr. Mansfield, 2 and 2 make 4. Do you want somebody to come along and say that? And so it was that kind of approach. It doesn't happen now, but it did then. So to stand there and say, well, yeah, I do actually. And then when well, the interesting thing is they go away, and the next day they came back and they said, well, actually, the person who did the work is not the person who made the statement. Ah, right. Well, who did do the work? Well, that means that they had to adjourn the case. They had to go and find the scientist who did the work. And, of course, when the scientist finally came, it wasn't as black and white as it was made out in the statement. So it was a question of persevering, having patience, not getting exasperated, not getting too angry, but feeling you've got to do you have to stick to it.
Okay. Now you became one of a small group of barristers who, I think it's probably fair to say, the police were extremely afraid of. And I'm going to do something a little bit unfair now, because the last time I saw you in court was in one of the Mark Duggan hearings, one of the inquest hearings, an early one. And you cross-examined the senior officer in the case. It was the IPCC who I think were investigating or in charge of the investigation. And you did it like this, Michael, and I'm just going to get up. So you are the senior investigating officer, and I'm you for the purposes of this demonstration. And you cross-examined him for about 45 minutes in a fairly terse, and I have to say, not aggressive, but a very firm way. And you never looked at him once. So you asked a series of questions. I'm going to ask you one now. Michael, tell us about Finchley, where you grew up.
No.
Take us to Finchley. Anyway, all right, well, he wasn't brave enough to say that. But the point is, what I'm getting at is that I'd never quite, some barristers did do it that way, but the effect was that it absolutely took away every scintilla of confidence that witness had. And it was quite a young, actually it was quite a young coroner. I think a more senior judge may have intervened and said something along the lines of, Mr. Mansfield, perhaps you could look at the witness or whatever. I think these days they would do that. What I'm getting at is, what I want to ask you about is your advocacy style, particularly in those kind of cases where you were having to break down a police case, the kind of tactics that you felt were necessary and appropriate.
Right, well, there's a story attached to this. Also, I'm not sure whether it's in the book or not, but it's quite... much of what I've done, everybody thought, oh, I'm ideologically driven. Well, actually, it's not quite as simple as that. It's kind of like Topsy. It just kind of grew through experience, and this particular point you're making was another one. I didn't go into court thinking this is going to be the way to cross-examine or anything of that kind. It was a pure accident of the environment of the court that I started to do that, and then more recently I don't do it quite so much. But I was in Gypsy Hill. Now, some of you know Gypsy Hill, maybe you don't, I don't know. Anyway, it's a sort of old Victorian area of South London. And there was a court, temporary court put up. They've closed lots of courts now, including this one. And it was in a church hall, a nonconformist, I say that for a good reason, church hall. And the judge was sitting up one end in the rafters, and it had been converted, and the pulpit was the witness box. And the jury was sitting in pews here, and we were in other pews as barristers. Is that the special branch ringing? It's all right, I pause for a minute because it can be distracting.
Is it coming from...
Oh, is it somebody record? Is it yours?
No,
I'll do it to music. I
haven't got a musical phone.
Anyway, so that's the layout of the courtroom itself. Jury, pulpit, judge up in the rafters. It's a straightforward burglary in the Elephant and Castle of a chemist's overnight in the weekend. So it's one of my first cases. And I'm shivering like mad. I don't know, how's this going to go? And there was a woman prosecuting, and she was very kind and sort of said, don't worry about it, just get on, So she finished examining this officer who'd gone to the scene over the weekend that it happened. And so I thought the natural thing is to talk to the jury. I mean, they're the ones I've got to persuade. So I spent the time, so all right, I'll stand up. So that's the jury there, witness box where you are. So I say, you know, well, what did you say? Because there are enough questions. You're going, well, you asked that. I said, I did, yeah. I said, what did you say your name was? Silence. Can't be that difficult a question. So I then said, did you bring, in the days when notebooks mattered, have you brought your notebook with you? Silence. I said, do you have a problem with my questions? Silence. I thought, God, it's my first cross-examination, and I'm not getting any answers. Anyway, I eventually obviously turned around. Yeah. You're gone. Not there. And I thought, oh. The judge sort of, his pince-nez falling off his nose. And he, what's going on? You know, where's the witness? And the usher has gone for a fag outside and having a break. And she's summoned in. You know, did you see the witness? No. The prosecutor was just sitting there sort of half laughing, and the jury knew what had gone on because they were starting to smile. And so in the end, the usher came in, walked up to the pulpit and opened the door, and he rolled down the stairs. He'd fainted. Yeah. And so the next thing, and this is all happening, and I haven't asked a question much, and then the St. John's ambulance bring in a stretcher, and he's carried out. And I think, so I sort of felt that maybe, I don't know. Anyway, I did get in the habit, and I think it wasn't particularly fair on all, some witnesses, yes, but mostly it's probably not fair. And judges did intervene from time to time and say, look, I think, as you rightly pointed out, you should face the witness. So I mix it. But there are some witnesses who really need to be dealt with in a particular way because you know, and everybody else knows, they're lying through their teeth. And you've got to unnerve them. And if you've ever had an argument with your loved one, it's very difficult if their back's to you and you don't see what's going on. So actually, it is difficult for the person who is being questioned if you're facing somebody's back. So I do it from time to time.
Okay. I mean, I'd love to spend the rest of this session asking you about, you know, advocacy techniques, what makes a great advocate. Let me just ask you one final question, and then I know we've got so much more to talk about. I want to talk about Stephen Lawrence in a minute. But what, do you think great advocacy really does make a difference? And can you point to examples where you feel that it has been your advocacy that has been I don't want to embarrass you, but there must be...
Oh, no problem.
Okay. All right, well, there must be instances where you feel that actually on that day, in that court, the way in which you presented the case or the way in which you cross-examined the witness, that really was a decisive factor. And what is it? What lies at the heart of that?
Yeah, I'm very dependent on what other people say. In other words, at the end of the day, somebody may come and say, that was great, or they may come and say the opposite, you know, what a load of rubbish, you're not on form today. So you can have bad and good days like everybody else. And it's very difficult for me to say that a certain type of advocacy does it and others forms of advocacy don't. All I can say is I think it's important, and this is what I say to anybody here want to be a barrister? I know there's one or two. Yeah, fair. There's somebody else wanted to be as well. Oh, good. Okay. Well, if you're still, I mean, I hope there's still a desire to do advocacy, whether you're a barrister or not. And I think the first thing is the element of it. So I don't feel it's gone well if I haven't engaged with the court. So if it's an appeal or something, you just got a series of judges. I feel it's important that they, you know, understand where I'm coming from. So I don't necessarily, I close the brief and I say directly to them. And I usually try and pick which one I think is most hostile and see if I can get them to lift their eyes up off the page or whatever and engage with them. Similarly with the jury, as I tried to in that first case, and engage with witnesses and so on. So engaging with people so they trust you and believe you, and you're not just doing a performance. You want them to understand what it is you're representing, or who it is you're representing, and so on. So that's the first thing. The second thing is, you really must not be boring. And now I say that because it still happens that people, they go to their lectern. Philip never does it, of course. They go to the lectern, and they read. Well, I had lectures at university where they did do that. They read the lecture, and I go up to them at the end and said, well, why didn't you give us the lecture on paper, and you needn't bother to come? But, I was really very welcomed there. But anyway, it's the idea that you must engage if you can. You leave the script to one side, and you have it there to jog your memory so that you've got the points that you want to make. But you don't necessarily make them in that order, and you wait and see how they're received, either by the witness, or by the jury, or by the judges, or whatever. So that's the second level, it's part of the rules of engagement, is that you have to ensure that the points you're making are being listened to, and therefore are done in a human way, and done in a logical way, and done succinctly. So people can see that there's an end to this, because if they think you're going to read 30 pages, they're switched off before you've even started. So being, brief, succinct, and compelling, and also, this is a third element, and don't worry, I'll end on this one, is that I think it's important for a little bit of humour, a little bit of levity, a story, and I have a stock of stories, which I used to use, particularly with juries, usually funny ones, to do with circumstantial evidence. And you get them away, from thinking about the case as such, but thinking about the principle. I mean, is there time for one? I don't know.
I'm sure there's time for one. Perhaps your briefest one, but yes, let's hear it.
All right, I'll summarise it because it could take a long time. No, it's to do with Conan Doyle and Mr. Watson going on a camping holiday, and they're lying at night, and Watson wakes up and he says, those stars, what does that indicate to you, Sherlock? And Sherlock says, well, probably, as far as meteorologically, I would say it's probably going to be a rather rainy morning. And they go through, horologically, what time of the day. He goes through a whole list. And so Watson says in the end, well, what's your overall, summation of the situation? And Sherlock says, somebody's bloody well stolen the tent. and the juries love it, because you say, you're not expecting that, and it's the unexpected assessment of a set of circumstances. You have to think outside the box. And if you've got an example like that, it helps to oil the mental wheels.
Now, people absorb information better when they're laughing or when they're happy.
Yeah.
Let me ask you, let's move on to the Stephen Lawrence case. If the Birmingham 6 and the Guildford 4 exposed massive issues and problems in terms of British policing, then the Stephen Lawrence case, Stephen Lawrence, of course, the black teenager who was murdered in an attack by a group of racists in 1993 in Eltham, the police investigation into that death clearly was riddled with malpractice and faults. You represented the family at the Macpherson inquiry that followed that case. And again, you were there at a moment of extraordinary, I suppose, an extraordinary cultural moment, a moment for our criminal justice system, for British policing. The Metropolitan Police were found to have been institutionally racist. It was a moment that really changed society. Can you just, were you aware of how seismic that was all going to be as you went through that inquiry?
No. I mean, again, it's a bit, I use the example like Topsy again. I mean, I'm approached by, well, he's a well-known solicitor now, Imran Khan, but then he wasn't. And he came up and he said, would you represent somebody who's not a defendant? So that was unusual in itself then, not so much now, because Macpherson himself said that people in the Lawrence situation should be entitled to public funding and representation. well, that's all got reversed through cuts and goodness knows what. So I said, yeah, okay, it's an unusual situation. And he said it's a murder, and so, well, okay, I've defended people on murder charges. It's South London, it's Lewisham. There was nothing about it that seemed to me, I just said, yeah, fine, I'll do that. And I met Doreen, and the months went by, and you begin to see, not through my own perception, and this is the other point I'd make very strongly, that the process that I've been through is through the clients. It's the people I've represented have educated me, you know, whether it's Lawrence, Bloody Sunday, Hillsborough, I'm doing Grenfell at the moment. It's the families, the people who've suffered, who've got a passion about them because they want change, not for their benefit, but for the benefit of the next generation. Then they imbue you. So slowly with Doreen, I began to realize, and Neville, they both played a major part in this, I sort of began to, through their eyes, see just how bad it was. But of course, I didn't know the extent, well, rather like Birmingham 6. At the beginning, I didn't know where it was going. It was just another murder case, but then it wasn't another murder case. And then it was, you know, there were more senior police officers down in Lewisham that night than the whole of Scotland Yard. Why are they all suddenly all down here? And then you realise that, you know, behind the scenes, there's much more going on, and of course you had the inquiry, which uncovered a great deal. And I think I want to pay tribute, if I can, I don't often get the chance, for Macpherson, a High Court judge who did the inquiry, along with a panel of others. But I think what interested me was he's the last person on earth who I thought would necessarily, and the family themselves were very unhappy about him chairing it because he came from a military background and all the rest of it. And it was thought that he would be far too conservative and he wouldn't understand the social situation. However, he changed. And that was what was interesting. He changed. He suddenly realized that actually the amount of malpractice was so great that he wasn't going to allow it to go unnoticed and unaccountable. There were 2 sections to the inquiry. And so 77 amazing recommendations. And they were largely due to his tenacity and all credit to his ability to turn it all around and prove that it is possible, you know, to see the truth and to act on it. So credit to him, and he doesn't often get the credit. He got a lot of stick at the time because at the time the police thought that the whole inquiry was treacherous, that it was undermining the fabric of the police force and the morale of the police force, and this should never have happened. Slowly, it's been realized through the efforts of Doreen and Neville at the beginning to hold the police to account, to come back year after year and say, where are the recommendations? What have you done? Only to discover that only a few have, and then gradually over the years, many, many more have been implemented, and they have brought about a sea change. And so in the end, when I did a lot of lecturing at police colleges, even though, you know, they weren't too amused by my activities in the courtroom, they wanted to hear me out of the courtroom. And I'm quite prepared to go and say, look, I want a police force that's responsible. I want a police force that's accountable. And this is what you've got to change. And you've got to stop looking at the Macpherson inquiry as though it's some kind of, as I say, treacherous event. It's actually intended to provide us with, you know, a vibrant and honest police force. And that has begun to happen. But of course, it can't be total. But it changed the course. And now the concentration is far more outside, you know, interrogations don't really feature anymore.